Welcome back to the LAWSTACHE channel. We're now in the fifth and final segment of a 5-part series dealing with vehicular searches without a warrant. In the previous videos, we've discussed consent searches, searches incident to a lawful arrest, automobile exception, and finally inventory searches. Those are the 4 most common exceptions to the warrant requirement that the Supreme Court has enumerated over the years. In this final video, I will not focus on any one of the 4 exceptions to the warrant requirement. Instead, I'm going to give you an overview of other concepts that you need to know when you're dealing with searches of an automobile. So let's get to it. We're now in the final segment of vehicular searches without a warrant. And today I'm going to discuss with you concepts that you need to know when evaluating a search of an automobile. We're not dealing with those 4 major exceptions to the warrant requirement. Instead, we're going to quickly go over these smaller concepts that you still need to know. So here's the first thing. Some of my clients have prior criminal history, meaning that they've pled to a crime and potentially waived or given up their Fourth Amendment rights. If that's the situation you're dealing with, first watch the videos that deal with Fourth Amendment waivers. I have a bunch of them on my channel, but essentially your attorney needs to look at what exactly you waived. Sometimes the officers can still exceed what's permissible under the Fourth Amendment, even if you've given up those rights. So carefully read the documents that you've signed and see how the judge sentenced you. The second concept is the plain view doctrine. Of course, the officers don't need to have a warrant if they can see the items that are illegal in their plain view or plain sight, meaning that the items that are illegal, you should be putting them in your trunk or in the glove compartment, and better yet, don't have anything illegal in your car in the first place. But if the items are on the seats and the officer can see it through the windows, that will not be a violation of the Fourth Amendment. And let's move on to a couple of other things. First, let's deal with spot checks. In this situation, the case is from Delaware. There was no traffic violation. Instead, the officer simply pulled over the vehicle to check the driver's license and the insurance. And the Supreme Court said that this was only marginal contribution to roadway safety. There were other means to check for driver's licenses and registration without pulling over the vehicle. Meaning that we don't have to permit the officers to pull over every vehicle to make these simple checks. And we already knew that. In order for the officers to pull you over, they need to have a reasonable suspicion that you've committed some sort of crime. And this is Delaware versus Prouse. Moving on to the pretextual stops. Of course, we know that sometimes officers make up a reason to stop you to really investigate the case further. What do I mean by that? Often enough, I get cases where the traffic violation is merging into a lane without signaling, rolling through a stop sign, and then they find drugs in the car. But sometimes you read that discovery and it feels like the officers already knew or had suspicions that there were going to be drugs in the car. And so it was really a pretextual stop. Unfortunately, we have a case of Whren versus United States, a 1996 case, that says that if there's a traffic violation, that stop will be legal, regardless of what personal motivation the officers might have. So it doesn't matter what the officers really thought. If there's a violation, they can pull you over. Moving on to rental cars. If the driver is authorized but not listed on a rental agreement, he still has reasonable expectation of privacy. What does that mean? It doesn't matter who the owner of the vehicle when we're dealing with the Fourth Amendment. If you borrowed a car from your friend and you get pulled over, you still have Fourth Amendment rights because you have reasonable expectation of privacy in that vehicle, as long as you have dominion and control over that vehicle. This is from Byrd versus United States, a 2018 case. Moving on to motorhomes. I have a bunch of videos dealing with motorhomes. One of the more notable ones is California versus Carney, a 1985 case. I encourage you to look that case up if you're dealing with automobiles, but really motorhomes. That's a special category of automobiles, and there's special rules involved with motorhomes. Then we're moving on to tips. These are anonymous, or sometimes the people call in and they will provide the name, and they tell the dispatch that they're seeing a reckless driver or a drunk driver on the road. And in this case, Navarrete versus California, a 2014 case, the Supreme Court tells us that the Fourth Amendment does not require an officer who received information regarding drunk driver or reckless driver to independently corroborate the behavior before stopping the vehicle. What does that mean? Well, in this particular case, the caller, who was anonymous, told the dispatch that such a vehicle, providing the license number, the color of the vehicle, and the mile marker on the highway, was swerving all over the highway. When the highway patrol approached the vehicle, pulled up behind it, the driver was actually within the lane. He was driving normal. And even without any violations, the highway patrol still pulled over the vehicle. Well, under Navarrete, the Supreme Court said that as long as the information provided by the caller matches the description, the officer can pull over the vehicle and investigate further, even if he doesn't see the reckless driving in front of him. Now, this was a very bad case, and there's a famous dissent by Justice Scalia who said that this invites a bunch of people to call in when they're upset at other drivers and get police to pull those people over. It doesn't make much sense. I have a video on Navarrete, and I encourage you to watch it in full detail and read the case itself. Moving on to passengers. Again, we have a bunch of cases dealing with what happens to a passenger when the driver gets pulled over. In Brennan versus California, a case that I've discussed before, we know that the passenger reasonably believed that he himself was intentionally detained. We know that when we get pulled over, it is unlikely that the passenger will simply get out of the car and walk away. And because of that, he's justified in asserting the Fourth Amendment, meaning that the passenger of the vehicle can also assert his Fourth Amendment rights, including illegal searches. Why? Because he's being detained by the police. A reasonable person would not feel free to leave from that encounter. And in Maryland versus Pringle, we have a situation of 3 occupants in the same vehicle. Mr. Pringle was actually in the front seat as the passenger in the vehicle. The drugs were found in the rear armrest in the back seat. Now, in that moment, the officer made a decision to arrest all 3 individuals for these drugs. And the Supreme Court said that's fine. There is probable cause to believe that a crime has been committed. Now, when we're dealing with probable cause, not only that there is a crime, but there's probable cause that that particular person committed that crime. But the standard is not beyond a reasonable doubt. We're not in trial. So any or all individuals in that vehicle, either Mr. Pringle or all 3, exercised dominion and control over the drugs. because in the moment, the officer cannot determine which one of the three actually exercised dominion and control. And so the Supreme Court says that all of them did. And then once these people are in trial, we can determine who is actually guilty or innocent. But there's enough probable cause to arrest all three. Moving on to canine searches. There's a number of cases in recent years, in the last 10 years, dealing with canines, dog searches. No reasonable suspicion is required for the officer to run the drug detection dog around the car, because there is no legitimate privacy interests during the stop. We learned that from Caballes, a 2005 case. Now, following that 10 years later, in 2015, we have Rodriguez versus United States, which said that the use of the canine exceeded the time reasonably required to handle the matter, because the mission of the stop determines the allowable duration. What does that mean? It means that if the officers pull you over for speeding, the officer needs to be actively giving you that ticket. And if he exceeds the time to give you that ticket because he's trying to call in backup, trying to get that canine to walk around the car, well, that search will be illegal. Once in a while, I get comments in my videos when we're dealing with these canine searches, and especially Rodriguez type situation. People tell me in the comments that 15 minutes is a maximum amount of time that the officer can give you the ticket, or 30 minutes, or 20 minutes. For some reason, people always want to have this bright line rule, but that's not what Rodriguez said. Rodriguez said that the mission of the stop determines the allowable duration. I have seen cases where 15-second delay was unreasonable, and I've also seen cases where half an hour was reasonable. Because it depends what you're being pulled over for and whether the officers are actively pursuing their mission of giving you that ticket or looking up the warrants or whatever else they need to do in order to accomplish their mission. So that's canine searches. And then finally, two more concepts. The GPS. If the officers install a GPS device without the person's knowledge underneath their vehicle, that is deemed an illegal search. They do need to have a warrant before they can install such a device. And we know that from US versus Jones, another case I've discussed on my prior videos, so go ahead and watch that one. And finally, the location matters. If we're at the border, the searches change significantly. And in fact, the officers can inspect the fuel tank, even take it off your vehicle to look for drugs. The Supreme Court said that the government has a paramount interest in protecting the border. So if you're at the border, the Fourth Amendment sort of relaxes. And at this point, the officers can often search your vehicle without any reasonable suspicion just because you're at the border. Hopefully, all of these concepts made you understand how searches of the automobile work. Hopefully, by now understanding these concepts, plus the other four, you learned more about automobile searches. If you enjoyed this series or this video, please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know. And if you can, tell your friends, tell somebody who owes you money to go ahead and subscribe to this channel. Thank you very much for watching, and I'll see you later.